Good Monday. I almost said Saturday, but good Monday evening, and thank you for joining us on From the Halls of Justice. We have with us the fabulous, uh, we have the Honorable Isabel Cohen, and she is a judge, and she served on the bench for 20 years. Um, she did 14 years in criminal jury trials, and she served 6 years in family law, and she is still active and hearing cases in mediation, arbitration, and in order to interview her, I pulled in some help. So we have with us a certified family law specialist, and this is Mr. Matthew Bogosian. And you know what? You are such a young man. Tell us a little bit about yourself.
Well, I've been, first of all, I was drawn into the field of family law at a very young age. I was a child of divorce, and I was involved in a move away. I was the child in the move away. And through a court order, I was sent on an airplane at age 5 from Los Angeles to Dallas, Texas, by myself, by court order, held back 30 days. And so I got to feel kind of the trauma that children go through when their parents litigate divorce cases. And my mom was also a family law paralegal,
All right.
worked for a family law attorney for many years. And so I kind of grew up in the world of family law. And so when I went to law school, it was kind of natural for me to go into that field. And so I studied family law, advanced family law, as well as what in the 1990s was sort of a new area, which was dispute resolution at Pepperdine Law School. And so I earned a certificate in dispute resolution, took 40 hours of training in divorce mediation. And so I've been practicing for nearly 20 years as an attorney and certified specialist in family law, but I would say almost half my practice is mediation.
Okay.
And what was so exciting for me was the opportunity to have Judge Cohen as a mediator in a case where I was the attorney of one of the parties. And it was fantastic because what I got to experience was not only did she study up on the law before the mediation, but even during the mediation when new legal issues came up, she was on her laptop going through and researching areas of law that even the lawyers had questions about. And it was fantastic. It really helped get our case settled. And so my advice to people out there is if you're involved in a contentious divorce case and your lawyers are going at it and you're running up huge bills, call up your lawyer, say, I want to use Judge Cohen as my mediator, settle my case now. And if, on the other hand, you don't have lawyers and you're just sort of out on your own and you don't know what to do, then you can contact me.
All right.
And I can handle people on their own from start to finish in their divorce case. So one way or another, we have some tremendous resources here to get people out of the system. And when Judge Cohen was on the bench, the system worked a little bit differently than it does now. And what I wanted to ask you about was what changes do you think have occurred in the family law court system that make it even more challenging today for people to try and get a divorce in the standard system?
Well, I will first say that family law has always had, and by family law I'm referring to the downtown courthouse, the family law courts have always been very crowded, and I had daily calendars of 40 cases and never got on the bench without having read every single one of them. The very large cases I tried to allocate over time so that they didn't fall on the same day. So the caseload was pretty big back then. When I retired in 2000 after 20 years on the bench, Judge Aviva Bob came in as supervising judge, and she added courtrooms to family law, which were sorely needed. The caseload went down a little bit, but the recession of 2008 resulted in a defunding of the judicial branch of government by about a third. and the Los Angeles Superior Court in particular, by about a third. And while Los Angeles County had courthouses, local branch courthouses all over the county in small towns and county areas and city areas in the county, it was forced to close many, if not most, of the local courthouses, such that people are required to travel long distances just to get to the central district where, for instance, probate cases were transferred from Santa Monica or to Pasadena if they live in Burbank for family law cases, which originally were in the Burbank courthouse. Those have been transferred to Pasadena. And this is a county without very generous public transportation. So when you add to the transportation woes and the travel requirements, and when these people finally get to the courthouse, they must wait and wait to be heard, and often, because the court is so pared down and the caseload is so high, they must come back repeatedly just to have their cases either heard in the first place or finished over months. I don't think years, but who knows. It has become prohibitively expensive and I'm talking about the middle class, to go to the courthouse for divorces. Litigation is has always been prohibitively expensive for the ordinary citizen, and settlement has always been a wiser, less expensive option. But as things stand today, the courtrooms have not been restored and the funding has not been restored, and people simply cannot afford to litigate anymore. And now I'm referring to the upper middle class. Mm. So the only sensible thing to do is mediate, which can be done in one day, or settle, and many, many attorneys settle cases without mediators. But clients really have to be compromise-minded, because otherwise, if they go to court to litigate, the expense can ruin them.
Now, for our audience, Judge Cohen, what would be interesting, and I'm going to give I'm going to give a question to you and a question to Matthew. It would be, what led you to family law? And for Matthew, it would be to bring it home and to make this really real. Describe a typical day in court for someone getting a divorce.
I will respond to the first question, and he can respond to the second. Okay. For me, relationships are really what life is about, and childhood is very formative of the adult. And so I was drawn to family law because there's a certain amount of problem solving that you can help people with, mm-hmm. and because I think we can always do it better.
That's true. And a typical day, when you're talking about the money, that's really what it boils down to. When you set aside the emotional feelings and the children, what's a typical day in court like, Matthew? Because now you're talking billing,
right.
And your billing should start from your time you're leaving, you're going to court, to waiting to be heard.
Right. So if you're instructing your attorney or being led by your attorney to litigate, mm-hmm. first thing you need to know is everything you've seen on TV is wrong. The closest analogy I can bring to the courthouse is the Department of Motor Vehicles.
Oh my God.
Consider yourself going through metal detectors, a long line, a long wait. Your case is on a list of 20 to 30 cases, mm-hmm. That are before the judge on a typical day. Yes, you are paying your attorney to drive through LA traffic, sometimes for an hour to an hour and a half each way, to park, to go into the courthouse, to check in, to wait. Then when you get there, you discover your case may not be heard for another several hours, and when it is, the judge may only have 5 minutes for you, only to tell you, we don't have time today. You're going to have to come back in 30 days, 60 days, or even 90 days, and nothing will get done in your case, even though your lawyers are telling you you're going to get a support order or you're going to get a custody order. Don't bank on it. And then what they do now, because they're so overwhelmed with cases, is they will send you to mediation anyway at the courthouse.
Okay.
So instead of doing it in the comfort of an attorney's office or Judge Cohen's office or anywhere you could just do a standard mediation, save all the time and the energy and the headache, you have to be told to go to another department and wait along with 10 other couples for a chance to get in maybe for 30 to 40 minutes with a volunteer mediator over there who hasn't even seen your file, hasn't done any prep work in advance, and is really just operating out of the goodness of their heart, which is wonderful. And they settle a number of cases, but it's extremely challenging and it doesn't give you the hands-on getting your entire case done. In fact, your best case scenario in court, if you can even get a settlement done, is on basically a scratch pad that they provide what's called a stipulation form. And most people can't even read the orders, and it's very haphazard. The quality, this is your life on the line. And the quality of the work that can get done in a private mediation is so superior than what goes on. And instead of paying your lawyer to drive and sit around and wait, you can pay your lawyer to go ahead and mediate this case and go issue by issue, which is what I'd love to talk with Judge Cohen about more.
All right. And now, you'd be fortunate to have Judge Cohen as your mediator. However, how can we get her? Because we know that you can't get her by just showing up in pro per, going, hey, can I sign up and get Judge Cohen?
Well, divorce lawyers know who all the private judges are. And most of us have had the pleasure of having Judge Cohen not only as a judge on the bench many years ago, but also as a private judge. And we all know how to get a hold of her. Most of us have her email address, and she's easy to find. And so if you've got attorneys involved and it's a contentious case, you just contact your attorney, you say, we want Judge Cohen, they'll find her. And then, like I said before, if you don't have attorneys or you can't afford to have attorneys at a mediation, you can contact me, and I can do a private mediation just for the public.
Now, Matthew, one of the questions that I'd like to ask you would be, in a marital case, if it's a short-term marriage, no money, they can do a summary dissolution. But if we're talking finances, property, custody, how is property divided in California?
Well, California is a community property state, and so property acquired during marriage is presumed to be community property. There are exceptions to this. Sometimes you inherit property from a family member, and so inheritances are separate property even if acquired during marriage. Also, gifts are separate property, and if you bring separate property into a marriage and use that money, for example, as a down payment on a house, you can get reimbursement back for your separate property contribution to the community asset. So a lot of people just think automatically the house is going to be split 50-50. And in many cases, it's not that simple. You have to look at the source of the funds of the down payment, and in some cases, there's a pro rata distribution under some sophisticated formulas that we have, but actually computer programs have made them much easier. And with the help of a forensic accountant or a mediator, we can help you figure out the percentage interest in a particular asset.
Now, for Judge Cohen, would you tell us how else would litigation and settlement or mediation differ?
Litigation, of course, is heard by judges in family law. The judge has taken an oath to follow the law, and cannot split the baby in half. Compromise is an act which can be performed only by the parties. The judge cannot be result-oriented. It's true that judges have the discretion to decide where the best interests of a child lies, but as for the rest of family law, it's pretty much determined by the way the cookie crumbles according to the law and the facts as found by the judge based on competent evidence. And there are many issues surrounding property and even support where there will be one winner and one loser. And it can be said that therefore litigation results in what I'm going to call a lose-lose situation, because there's one winner and one loser. I don't know if you want me to also say what I think about litigation and children.
Yes.
Okay. Children by nature love both of their parents, and parents who fight by litigating, well, I should start by saying parental conflict is bad for children, period, because they form an identity out of identification with each of the parents, and if they receive a message, either express or implicit, through tone of voice or body language or facial expression, that the other parent is not love-worthy, they become conflicted inside, and it really affects their ability to develop an identity which is strong and which is felt to be themselves. So litigation really is a fly in the ointment. Even if the parents don't expressly embroil the children read their parents like tea leaves, and it polarizes the parties terribly. They get up on the stand and testify against each other. It compromises their ability to co-parent the children in the future. Whereas, on the other hand, settlement results in peace now. The children can be sheltered in a way so that they do not become psychologically conflicted, and so that their development, psychologically speaking, is not compromised now and when they become adults.
So I was listening to Matthew, and I'm listening to you, and with all the cases that are backed up in family law, and as Matthew stated, if you're going ahead with litigation and you go into court, and how often, if you request an order for temporary support, how likely are you to get it that day? What can you do? Do you think it's going to happen?
Well, my experience has been a lot of these cases are continued. Typically, your attorney will file what's called a request for order. It'll be set on a particular date. The other party may or may not have counsel at the time this is filed. If and when the other party has counsel, often the attorney has a conflict in his schedule or her schedule. This results in a need for an agreed continuance, and courts expect parties to stipulate to a continuance just as a matter of professional courtesy. So the odds of you even having an initial support order heard on the date of the initial RFO isn't always guaranteed. And then even if you show up, the court may ask, are there any witnesses? Do you need to testify? Well, if you need an evidentiary hearing, the court may say, I don't have time for you guys today. Come back in 30 days, 60 days, or 90 days. So while your lawyer might be telling you, yes, I can get you a support order very quickly, the truth of the matter is the faster you get yourself into mediation and settlement, the faster you're going to get your support order. And even if a judge makes an order that you really like, but the other side doesn't, number one, they can appeal, which can drag it out further. Number two, if they get an order they don't like or feel they can't afford, they may not pay, and then you have to go through enforcement procedures. An agreed settlement is usually a compromise that both people feel they can live with, and the chances of somebody actually complying with the order are much higher when it's agreed to.
Now, this is a question for Judge Cohen. Are some cases, or which cases are more appropriate for litigation than others, would you say, in mediation?
There are cases, of course, which are inappropriate for mediation. And really, when I say mediation, I mean to say settlement, because effective settlement happens all the time between attorneys without a mediator. But, of course, settlement also occurs with mediators. So those cases where there has been either physical or emotional abuse, or cases where one party who may be the obligor or the payor, if the matter goes to court, obfuscates or hides assets or is less than truthful about the extent of the community estate or his or her separate estate, assets, income, those cases are probably not appropriate for settlement, because voluntary settlement is just that. It's voluntary. Mediation, leaving aside for a moment the required mediation of all custody matters before you step foot into the courtroom. There is a court services division in Superior Court which employs social workers and therapists who do attempt to help the parties to settle disputed custody cases just before the parties try a case. But leaving that aside, where parties elect to mediate or settle a case, they do so voluntarily, and where the sides are not equally powerful and one side has been abused either economically, financially, or physically, that kind of a case is probably going to be helped by a strong order of court. Mediators and attorneys can't make orders, and they, even of their own clients, they don't have power or control.
What type of order would, or should an attorney, or maybe Matthew would say this, would you seek if a spouse is not being forthright, more than honest in their disclosure, and they're hiding assets and funds? What do you do?
Well, typically in cases like this, parties will engage in what we call formal discovery. Formal discovery is where documents are served on the other side, requesting documents and information within a certain period of time, usually 30 days. If the other side does not produce all or a portion of the information or documents requested, then the attorney or party typically will have an obligation to meet and confer, usually by letter, explaining where the response was deficient, and if it still does not get corrected, that party can then file what's called a motion to compel, and even request monetary sanctions in the form of attorney's fees and costs for having to force the judge to essentially order the party to produce the documents or the information. If the party, even after an order, and this sometimes occurs, but it's rare, still does not produce records after an order, the party can then request what are called evidence or issue sanctions, where effectively the party is precluded from bringing in evidence or arguing a particular factual point in support of a request for relief at the time of trial. This can be very substantial, and I've actually been involved in cases where issue and evidentiary sanctions were issued because someone simply would not produce the records. But it's a very expensive process, and I feel for people who are involved in cases that are highly contentious where the money's there, but one side simply wants to hide the ball.
So, Your Honor, will you explain, we're down our 3 minutes, the mediation privilege? If a couple enters into mediation, what's going to happen?
The mediation privilege is found in the Evidence Code, and it was created by the legislature because without it, there would be a chilling effect on mediation. People would be very loath to share information or make concessions or even admissions, and as a consequence, under the appropriate section of the evidence code, those who engage in mediation are completely privileged. The offers that are made or refused can never be brought to light in the courtroom or anywhere else. And the entire purpose, of course, is to keep the mediation, to get the people into mediation in the first place, and to keep it going in the second place. There are some exceptions for instance, issues of attorney's fees or documents that have to be filed in any event in the court. And then the biggest exception to the mediation privilege is a settlement deal.
We have 1 minute, 47 seconds. It's counting. Number one, I would like to thank you again. Judge Cohen, you are a judge of judges. I mean, you are absolutely fabulous. And
you're very kind. Overly so, believe me.
But also accurate.
Oh, thank you, Matthew. And you won
well.
my heart because your mother's a paralegal. So I'm over here going yay, and I really am. I'm so honored to have you both on the show tonight. And once again, Judge Cohen, in order to even have Judge Cohen as a mediator, you need an attorney. And so she would be available mediation, private adjudication, a discovery referee. And Matthew, you're absolutely fabulous. I'm just really impressed with your youth and your knowledge. So
I look young, but I've been doing it a long time. And I've been through my own divorce, which actually made me a more compassionate divorce attorney. Prior to getting my own divorce, I was a little bit judgmental about what my clients ended up doing sometimes during the case. And after I went through my own, I realized that the emotions were so high that I've become a lot more compassionate about what people go through.
That's awesome. I think in family law, it's very, very important. And once again, Judge Cohen, you are a judge of judges. I think it's just awesome. I'm so honored to have you here on the show.
The honor was mine. Thank you very much.
And mine as well.
Well, thank you for joining us on From the Halls of Justice. Join us again next week. And as always, we wish you love, health, and peace. And tune in next week and you'll find out all the things that you might want to ask your attorney, and if you have to appear before the judge.
Thank you.
Thank you.
This is marvelous.
Thank you so much, Wanda. It was a lovely experience. Thank you, Matthew.
That was fun.